My name is Jill Coyle, and welcome to another episode of No One Dies from Divorce, where we talk the nitty-gritty aspects of divorce and help each other come through this not only surviving, but thriving. I'm a divorce attorney, and I'm interviewing other experts and people just like you who are going through or have been through a divorce, so you can have the latest and greatest information on all things before, during, and after divorce. Let's dive in. Okay, hi, welcome to another episode of No One Dies from Divorce. Today we are talking about how to attack or defend premarital agreements. And my favorite song by the good Ye, Kanye, we're not saying she a gold digger, but she ain't messing with no broke to broke. I'm really excited for my guest today because I would say you are somewhat of an expert in attacking or defending premarital agreements. His name is Ryan Kalamaya. Did I say that right? I should have asked you prior, but...
It's all good. It's Kalamaya, but Jill, I was a baseball player, and I've had my name mispronounced so many different ways that I'm like a dog. I'll come to anything.
That's awesome. Well, I don't mean to be disrespectful, but Ryan, we're just grateful to have you on the show. Let me tell you, our listeners, a little bit about you and your background. So his bio is that his life is full of peaks and valleys. I just found out he's a skier. He also played baseball in college. That's pretty cool. So Ryan and his team meet people when they are suffering in an emotional valley and facing the prospect of climbing their own personal mountain. They sort through their baggage, help them plan their journey, and guide them to the summit. That's actually seriously an eloquent way of saying exactly what I say in my book, which is No One Dies from Divorce. I love that, Ryan. So Ryan is the managing partner of Kalamaya Goscha. Gosh, I should have asked you how to say this. Goscha. Oh my gosh, I'm sorry, but he's an innovative and ambitious law firm that pushes the boundaries to discover new frontiers in family law, personal injury, and criminal defense in Colorado. He is the co-host, Divorce at Altitude, a podcast on Colorado family law. And Ryan specializes in divorces involving complex property valuations, including closely held businesses, family partnerships, and trust in interests, attacking or defending marital agreements, and parental relocation or high conflict custody disputes. He was named to the Rising Stars list by Super Lawyers for 5 years before being selected to Super Lawyers for 2022. He has a 10 out of 10 rating by Avvo, where there are over 80 client reviews and testimonials. Welcome to the show, Ryan.
Thanks for having me, Jill. Excited to be here.
Yeah, we were just getting to know each other a little bit before the show, and it seems like we have a lot of commonalities in the fact that we tackle high litigation, high asset, high net worth cases. And it seems like we've become kind of the expert in our field in helping people protect not only their future, but their family and their fortune. And that's kind of what I see, that we have that commonality, and that's what we're doing in our line of work. Ryan, I also love it because I believe that we have kind of a commonality in the fact that we're helping people understand that divorce is just a moment, and it could be used as a platform to kind of carve out what is your future going to look like. And let me help you through. Yes, this is a trying time, but it doesn't have to be the end. It can also be the beginning. So excited. We're going to talk about premarital agreements today because I think it's a question a lot of people have. A premarital agreement can either be looked at the best thing in the world or the worst thing in the world. Would you agree?
I agree. And I think it's interesting that millennials in particular seem to be more open to premarital agreements because they've seen their parents go through a divorce. And so at least what we're seeing here in Colorado is a lot more younger people seeking out premarital agreements to spell out. I also think that people are waiting longer to get married, so they have more at stake. And so it's just a little bit more accepted. And when you got Kanye West out there singing and its praises, then, obviously masses are going to follow.
Right. And we did a podcast a few months ago about him and Kim's divorce. And that's kind of been something that I've been doing on the side as we've been doing these celebrity podcasts talking about divorces of celebrities with tons of money, tons of assets. And so it's always interesting to see the ones like, how's the premarital agreement standing up? Which ones did it? Which ones didn't? And so it's this is a topic that has to be discussed now. It just does.
Indeed, when you've got Dr. Dre going through divorce and they are challenging the prenup in Dr. Dre, I've written about it and spoken about it, but he's got reportedly around $1 billion, and that is a big issue. Kenny and Kanye, obviously, I don't know, and no one really knows that the real details about whether or not they're going to challenge a prenup, but my understanding is that their wedding got hung up because they were negotiating their premarital unit. But yeah, you see it all the time. I mean, they have the Sim Kim and Dr. Dre have the same divorce lawyer, Laura Wasser, in Hollywood. So it comes up.
Yeah. And, Kelly Clarkson, we did a celebrity podcast on her and her divorce with Brandon Blackstock. And he challenged the prenuptial agreement, which the judge ruled that it was going to stand and that it was valid. And she ended up just reaching an agreement with him that he's getting like 5.16% of her Montana ranch. And I had to laugh when I saw that because it's worth millions and millions, and he's getting like, I think it was like $800,000 worth. So this topic is important, but I also want to stress that this topic is important not just for these millionaires, not just for these celebrities, but for the everyday person, for exactly those reasons that you just said below. Like marriages, people are getting married later. They're coming into marriages with more assets. So this is a conversation for everyone, not just those people that we're talking about in the news. So the first question I want to ask you, Ryan, is what would be the purpose of a premarital agreement?
So the purpose of a premarital agreement, and when I discuss these terms, you'll hear me say marital agreement, premarital agreement. I think it's helpful to step back. When we talk about premarital agreement or a prenup, then that is an agreement that spells out various things in context of a marriage. And there's both what happens if there's a divorce, and then also what happens if someone dies during the marriage. But then you also have a marital agreement, and that or a post-nuptial agreement, and that can occur for people that are already married. But the purpose is to have predictability and to lay out who gets what, the forks and the knives. And it's always a challenge because you've got this, you mentioned this snapshot in time, and it's a period, divorce is a period in someone's life. Really what we are talking about is two snapshots in someone's life, because we're first talking about getting an agreement, whether it's before someone's married or during the marriage, and then what happens when there becomes an issue. And most of the time we're talking about in the event of a divorce and whether or not that agreement is enforceable. You also see somewhat of a related, but I'm not here to talk about it, of what happens when someone dies, because there is litigation by a family saying, well, I'm not going to get as much, or a spouse saying they're not going to get as much as they thought, or the agreement. They're trying to attack the agreement, and it does come up in estate or probate litigation.
Right. And the one thing that I think a lot of people think is, a premarital agreement, determines that I don't trust my spouse or my future spouse, and therefore, I'm doing this out of like some kind of selfishness. But this is what I want our listeners to hear, and I'm sure you say the same thing, is that a premarital agreement, first of all, is only valid if the event that it's protecting happens. So if you don't die, or if you don't divorce, premarital agreement means nothing, right?
Right. And you always hear, well, why are we having an agreement about if we're going to get a divorce? I'm not going into this wedding, or I'm not in a marriage with the expectation of getting divorced. And so there's always that argument. But then it's, well, are you marrying me for my money? And if so, then you wouldn't have a problem signing this agreement. And I think that what I said at the beginning is that millennials and people just in general are a little bit more pragmatic about that this could be an issue. We could end up getting a divorce, and we want to spell out business or support, and we can get into what people do and what laws can control in terms of those sorts of agreements.
Right. So should everybody have a prenuptial agreement in your opinion?
Let's see. I've never been asked that. I don't think that it's right for everyone, but I certainly don't think that it's a bad idea if people want to have some predictability. And it could be that they want a particular law to control, or a state's law. So Utah, there could be some aspects where they want that state's law to apply if they move to my neck of the woods, Colorado or California,
Right.
and they get married with an expectation of something happening. So
Right.
I don't know if it's right for everyone, but certainly I've had a lot of clients, Jill, I'm sure you have, where there is a lot of money at stake, and it can result in a ton of uncertainty, and they wish they would have had a premarital agreement.
Right. You know what's interesting? Because I used to say, oh, it's not for everybody. If you're young and poor, and you're planning on building a life and wealth together, then a premarital agreement isn't necessary. However, in my later years, I've actually come into some scenarios where I think if you're young and poor, you should have a prenup. And this is an example. My husband's a physician. I finished law school the year we got married. So I was going into the workforce before he even knew he wanted to go to medical school. I put him through school and, through residency, and we had that debt that we now paid off, but it was a huge burden on our family, and I supported him through that 100%. I look at our experience, and I've written about this in my book, is that we almost got divorced on year 4 of marriage. And he was in his second year of medical school. His debt was not in my name because he got federal loans. They were in his name. But we didn't talk about that. Hey, if we get married, what does this debt look like? And what I've actually been doing this is that I get a lot of questions from doctor wives around the country. People reach out to me because they know that I am married to a doctor and I'm a family alert. What I've learned in states like Florida, that debt doesn't matter. It's marital debt. And I have people coming to me who, their husbands in residency are just a first year out of, in what we call it gets better. They're actually making a physician's salary. And the Florida courts rule that debt is marital. So I'm now in the scenario, and if anybody's listening to this, if you are going in this direction where you are putting somebody through medical school, I would encourage you to do a premarital agreement that if there is a divorce after that debt that he inquires or she inquires for medical school or for dental school or PA school, whatever it is their debt. That's just one of the scenarios that I'm now thinking that you should rethink this whole young and dumb approach, where if you're young and dumb and you have no wealth, that maybe a premarital agreement isn't worth it. But I don't think that that's true anymore. I think it should be assessed in every case, and you should be thinking about protection in case these kind of events happen. Any thoughts to that? Have you seen scenarios like that where you're like, oh, that makes sense?
Certainly. But the premise by which you are suggesting that, Jill, is this assumption that it's going to be enforceable. And so what we're here to talk about is an agreement that people have done or are contemplating doing. And they, I'm sure you've heard it, the bulletproof prenup. Oh, my premarital agreement is bulletproof. And there is law across the country, not just Utah, Colorado. Florida has some really interesting case law about whether or not these agreements are enforceable. And when you are young and dumb, and then ultimately someone has millions of dollars later on it happens, then there's a reason to attack these agreements. And there are different avenues to pursue that sort of line of attack. But then on the other hand, it's the, well, where are my weaknesses and what things should I do or should not do when we have a premarital agreement? Because you can open up these sorts of agreements through behavior during the marriage that people may not realize.
Yeah, I absolutely agree. And, with Utah being an equitable state, I just have to go into court and say a prenup's not equitable in, a little bit more detail to that. And there are ways that we can punch holes in a prenup. So I think the first thing we need to talk about is, what do you need to do to ensure your prenuptial agreement is valid?
So I think it depends on what state you're talking about. Colorado and Utah are in what are called uniform. There's a uniform act, and it's promulgated by there's an entity and the American Bar Association, and they can have these uniform acts. So, and states can either change and modify these various uniform acts. But in Colorado, as we sit here today, both are reliant on the Uniform Act.
Yeah.
And the basics in Colorado, the history is, they've had originally they started out with using case law, and that's really kind of how we've gotten to where we are. And I think it's helpful for listeners to understand the history a little bit about these agreements, to understand how they're attacked and what the purpose is. Ultimately, a premarital agreement and a marital agreement, they're contracts, but they are special kinds of contracts. They date back, thousands of years. The first premarital agreement was from ancient Egypt in approximately 3,000 years ago. And so, but originally what they were intended to do was to spell out in second and third marriages who got what if someone predeceased. So if a lord predeceased his wife, he wanted to make sure that his children were provided for. And up until the 70s, then 60s and 70s in Colorado, Florida was one of the first states to recognize a premarital agreement in the context of a divorce. Mm-hmm. And so states have dealt with it differently, but ultimately we now have a uniform act. In Colorado, they've gone through a couple different iterations. And so we have different requirements across the country, but generally speaking, it has to be in writing. There's been a couple of cases here in Colorado recently about oral contracts, but really it's got to be in writing. The other usual requirement is there needs to be financial disclosures. You have to know what you're giving up, or you have to know what all is going out there. And different states have different rules on how detailed that statement is, but it would be a simple net worth statement, how much the house is worth, the business, those sorts of things. And if you're young and dumb and you don't have anything, it's pretty easy to do. And then you get into questions of, does an attorney have to be involved? In the Uniform Act and here in Colorado, there's standard boilerplate about, that you need to have an attorney, and if you understand you're waiving various rights. And so there are those requirements, and generally across the country, there are certain prohibitions. So, for example, child support is generally prohibited to be kind of in an agreement, or at least enforceable in agreement. You can't say how much child support is going to be. Neither can you say what the custody or parenting time arrangements are going to be. You don't know if in 10 years, if Johnny and Sally have a premarital agreement, Johnny could be, a raging alcoholic, horrible father. And so you can't spell out that he's going to get equal time or whatever the case may be. So those are the general requirements. And, it's premised on voluntariness. It has to be voluntary, and we can get into that. But those are the general requirements for a premarital agreement or marital agreement.
Right. And this is why it's good to understand these parameters, because, we get a lot of people that they print out a prenup, a general prenup from the internet, and it's really long and it's got a lot of boilerplate legal language, and they sign it. And then they come to us and they're like, enforce it. And we're like, well, do you even understand what this paragraph, And then they're like, well, this is what I thought it meant. But at the end of the day, when you're contesting a contract, the court is going to take the four corners of the contract. So they're going to basically say in the most simplest terms how they believe the paragraph. So that's one of the reasons why, even if you don't hire an attorney to draft it, it is very, I think, worth your time to at least have an attorney review it so they can spell out what this boilerplate language means, because words matter in contracts. And at the end of the day, the court is going to try to uphold whatever they believe the four corners of the contract is. So if you don't even understand what it is, and then you come to me and you're like, well, this is what it means. And I'm like, no, this is not what this means. And the court's not going to believe that, it could put you in a predicament that you don't want to be in. So I know a lot of people don't love the thought of spending money on an attorney, but this is what I always tell people, like if you're trying to protect yourself, your future, and your family, the $300 for an hour consultation with Ryan, or Jill Coyle is going to be well worth its weight in gold to ensure that you're getting exactly what you need and what you want to do that exact thing. So one of the things, okay, we get this a lot, and I thought we could talk about this, Ryan, is like the top tips to know when you're trying to come about with whether you're going to draft one or not do one, or how you're going to do it. Like, I just wanted to go back and forth and have kind of a conversation of what you believe are the top tips, or what you would suggest and advise people thinking about this. So I thought I'd go first, and then you can kind of share your top tip. But one of the things I wanted to say is, hiding or not disclosing assets in a premarital agreement or discussion will never go well with you. So if that's what you're kind of thinking, is you're trying to get that boilerplate disclosure, paragraph in there that says, oh, she's had the chance to know about my assets and she's decided to not care. And then you want to come to court in 12 years and say, oh, but I had $3 million that I never told her about, and where it was and where it was going and how it grew and blah, blah, blah. It's not going to help you in court. So.
No, and just to piggyback on that, Jill, in Colorado, and there's case law across the country that stands for a similar proposition. If you don't disclose it, it is not part of the agreement, and so the intent of you excluding it or withholding and not being transparent is going to end up coming back to haunt you and really come back to bite you. So 100%. And I guess another tip that I would have is don't procrastinate, because it's one of those things where we frequently will see it in the case law. I'm holding up a book here, and it's attacking and defending premarital agreements, and it's case law across the country where people have attacked a premarital agreement. And the reason that they do it is because they have something to fight over. And if they, one of the most common questions or issues that arises is, well, I was forced into signing this agreement, and it was the day before the wedding, and I was forced to sign it. And the case law is pretty clear across the country that you don't have to get married, so there's a remedy. Don't get married. But if you walk down that aisle, then, and I hear it a lot. I planned the wedding. We spent all this money, and, then I was presented this. But if you are discussing a premarital agreement, don't wait until the last minute, because you are then opening up at a later point for this to come up. And there's a case in Texas that kind of spells this out, where the husband said, I want to get a premarital agreement. The wife dragged her feet. The husband then got an attorney for the wife. It was handpicked by, him. And then, he waited until the last minute. There was some negotiation, which is critical in terms of the enforceability. And then right before they were about to walk down the aisle, she thought that, she had kind of stalled him out enough that it was not going to be an issue. But he then presented an agreement for her and said, your lawyer signed off on it, when in fact he hadn't. And, the court set aside that premarital agreement down the road just because there was so much bad faith going on. But really, don't open yourself up. If you have done it a week beforehand and you've had negotiation, you have attorneys, that agreement generally is going to stand up. But don't wait.
Yeah, absolutely. I mean, the whole, I'm canceling the wedding unless you sign a premarital agreement, is not going to stand in court. And I've won that argument in Utah before because, again, we're an equitable state and the court is not going to find that that was done. And we're going to get to the exact ways of how you can challenge the validity, but like coercion, fraud, you feeling like you have no other way is definitely, and then I love what you said. Like, if you don't get an opportunity to negotiate the contract that you're then entering into, that's going to be a problem as well.
Yeah. So if you're doing this on your own, and I would, you asked earlier, does everyone need to have a premarital agreement? I don't think so, but I will tell you, my firm, our policy is that we will not draft a premarital agreement unless there is another attorney on the other side.
Yeah.
And the reason is that if there are two attorneys involved, one representing the husband, one representing the wife, and it is highly likely that there is going to be an enforceable agreement. And when you have that, two attorneys on either side, it's really hard to argue, I didn't know what I was giving up. They didn't do this, they didn't do that. I've seen that before, but my firm's policy, and a lot of divorce lawyers, I'm sure it's in Utah, they won't do premarital agreements and marital agreements because the malpractice risk is so significant, where they might make $300 or a couple $1,000s in drafting it. But if later down the road they botch it, and I've seen it. I had a $30+ million divorce, and it was just these small town lawyers in Grand Junction, right on the border of Utah and Colorado, and they botched it. And there was a significant malpractice claim against them because they didn't dot their I's and cross their T's.
Yeah.
So I would go so far as to say that if you're going to do this, do it right and have a lawyer involved. It will be don't be, penny wise, pound foolish. Spend the money. If you have enough that you're really thinking about a premarital agreement, then I would highly recommend, hiring a lawyer.
Right. One of the things also that I guess I frown upon and I advise against is when you have people that come in wanting a premarital agreement. They have premarital assets. That makes sense. Protection. But then they also want to protect every dollar and asset that they acquire after the marriage. Now when you're looking at Brandon Blakestock and Kelly Clarkson, who both are high net worth individuals, when you're looking at Kanye and Kim Kardashian, okay, that makes sense. You make your money, you keep your money. And that's what happened with Kelly Clarkson. She made way more money than Brandon, and she gets to keep it. But if you have if you come in, you're a guy and you have a business and you're planning on, creating an exponential amount of wealth, and then you have a spouse that doesn't work and is planning on staying at home with the kids, you coming into a premarital to basically say whatever you earn, whatever you make is yours. At the end of the divorce in Utah specifically, that's another way to challenge the validity of the prenup. Because the court is not going to allow your spouse to become a public charge. And it says right that. So if you want to make sure that she can't get alimony, you want to make sure that she's not going to have any of your assets, including, real estate or assets creating wealth, but yet you want her to stay at home and basically, live off of your money. You're going to be in trouble.
Well, I couldn't agree more, Jill. And the way I explain it to people is that really there's three avenues to attack a premarital agreement. The first is on procedure. So it procedurally has to be fair. So that gets into the voluntariness, it gets into the writing, it gets into the disclosure of assets. I had a case where the disclosure was not initialed and dated before the wedding. And so there was an argument that it was not disclosed ahead of time. And so we attacked it based on that basis. Attorney, these are getting into procedural issues. Was it negotiated? And if you have a negotiation, and if you're doing this on your own, or any real experienced divorce lawyer, or not really divorce lawyer, but any lawyer that does premarital agreements, they're going to save those emails and the documentation showing the negotiation, and that they can show that it wasn't just this take it or leave it agreement. But then that gets into the second avenue, and that's substantive. So if you say every single dollar and cent is in my name, you're opening yourself up to a line of attack. That's a separate issue from, is this a viable relationship or a basis to start off a marriage? Is this really what we intended, where you get all of your money and what's yours is yours? It's fine if you want to carve out a business, but what about the spouse that stays at home and takes care of the kids? Isn't that worth something? And that's where you get into the substantive aspect. So again, waiver of alimony or maintenance here in Colorado, you look at the agreement or the waiver at the time of the divorce and whether or not that's fair. So you can have a waiver of maintenance or what we call spousal maintenance or alimony, and it sounds like it's the same thing in Utah, but you determine whether or not that's fair at the time. So property, you can have every dollar and cent in property, so the business, all of that. It can be completely unfair, but it's enforceable in Colorado. But generally speaking, every state's going to have some sort of release valve. It's either going to be on the property side or it's going to be on the support side. And, so going to Dr. Dre, the court, California, could enforce the property. So all of his recording rights and business interests and Beats by Dre and all of that could be his, but his wife was asking for $1 million a month in support. And so it's because, you kind of give one and take away with the other. So it's that sort of element that really, I think people don't realize. When you have an agreement that says, I'm going to give you a certain dollar amount in alimony, it's more likely that that's going to be enforceable, even if that might be on the low side. And it really kind of depends on the state by state aspect. So, but attorney's fees, we see this a lot where there's a waiver of attorney's fees or the prevailing party, and that gets in the substantive. Is that really fair? But generally speaking, what I encourage, I can't tell people this is what you should do in your marriage, but generally speaking, I will say it needs to be fair. And if it's fair, then it's more likely to be upheld, and then the divorce process is a lot easier.
Right. And that's why, I refuse to draft a premarital agreement that I find to be, unconscionable or unfair for whatever reasons. We get a lot of second marriages. Second marriages, I think, want premarital agreements more than anything, which makes sense. But again, I think that they've just been a little bit jaded by their first divorce, so they really want to go far into that of, I got to protect myself. And at the end of the day, I just look at them and say, you're setting yourself up for failure, and I'm not going to be part of that. Because unconscionability is a way that you can, contest the validity of a prenuptial. If it's so one-sided, if it's so unfair, failure to disclose is what we talked about, is another reason. And then obviously duress and coercion would be another reason that you could, challenge the validity of a prenup. One of the things, and maybe you have some tips or advice on this, is that, it's really hard for the person that doesn't need the prenup because they have no assets, but the other party wants it. It's really hard for them to feel like they have a leg to stand on negotiation. So a lot of times they think, well, it's not my money. I'm not bringing anything into this, and so therefore I why should I argue or why should I negotiate with him or her? And I should just sign it. But one of my advice and tips is you absolutely have the right to negotiate to protect yourself, your future, and your family, just like he does. You may not have the assets, but you definitely have the ability to look in the future and think, what do I need to make sure I'm taken care of or my family's taken care of, especially if you guys want to have kids. So my advice to you is if it's a one-sided negotiation where he's like, sign this or else, you might need to be reevaluating if your relationship is even where you want it to be anyways. What's your thoughts and advice on that?
I agree with that, Jill. It's one of those things where I can't tell someone whether or not they should get a divorce. And going into a premarital agreement, I can't tell them whether they should or should not sign this. But what I can tell them is you should be prepared to walk away from either signing this agreement and having this wedding, or you may end up not having anything. And is that the life that you want? Is that a fair result? And what is your marriage? And people have different understandings of financials. So second in marriage, that's going to be different than someone that they're starting a life together, and it's kind of their first life, their first mountain, so to speak, and they're going to climb it together. They're going to have kids. So you really get into that. And I think those are healthy conversations to have in any sort of wedding scenario where, how are we going to address money? Are we going to have a joint bank account, or is it, hey, I pick up dinner one night and you pick up dinner the next night? I think those are healthy conversations, but I agree with you that people need to be prepared to walk away. And that's a hard conversation to have with someone because they're in love. They're really excited about getting married, and they don't want to have the embarrassment of people showing up and or having to cancel the wedding. But the alternative is that they could be 10 years down the road and they could be in a really bad spot.
Yeah, exactly. And the thing is that's why these conversations need to be had early. I mean, we talk a lot about prepping for marriage, and if you're not having hard conversations before you get married, what are you thinking? Like we live in a day and age where there should be no like belief in marital bliss. Like you need to have these hard conversations, especially with people that have been married before or relationships before. We always talk about in divorce, like you don't want to be running into your second marriage, running into your second relationship because you need to fix the broken self first before you can. And we have to remember, like we have to be dependent on ourselves because marriage is never going to bring happiness. And that's not the platform. And if you're looking for that, then you need to get help and understand happiness comes within. So when it comes to this hard conversation, if you're scared about having this conversation, you might need to step back and think, why? Why am I scared? Or why do I feel like I can't fight back? Because these are the hard conversations. You should be able to have very good, healthy conversations with that person that you're like supposed to be in this like honeymoon bliss with. So don't be afraid of that. And the advice that I would give you is that these hard conversations now lead to very more peaceful conversations down the road. And, crucial conversations is one of the biggest things that I do in all aspects of my life, whether it's my relationship with my husband, my kids, my employees, my clients, is that these crucial conversations lead to expectations, lead to good results, and leads to better relationships, better conversations. And why wouldn't you want to be starting that off on the right foot with your marriage?
Right. And that brings up the third way that you can attack a premarital agreement or a marital agreement, and that is through change. And marriages change, relationships change, and people, they can change during the term of the agreement. So there's the third way of attacking is waiver, abandonment, modification, revocation, or rescission. And essentially it's you agree to one thing, but then your behavior is completely the opposite. So it might say, the agreement could say, we're going to keep all of our property separate, or all of our money separate, but then during the marriage, you make it all joint.
Yeah.
And so the question is, does that mean that the agreement is now unenforceable? There's also the modification, or at least what I understand happened in Dr. Dre's is a revocation. So it's the drunken argument, and I had a case once where the husbands the agreement itself became an issue in their marriage, and in front of a dinner party, he threw the agreement in the fire and said, "I'm done with this agreement." But most agreements will say that it has to be rescinded in writing.
Right.
So there has to be an agreement. So just tearing it up, seen that. I had a Valentine's Day, card, and then it was the shredded premarital agreement, and that whether or not that is a revocation or a rescission. And so those are the sorts of things that you get into, the emails back and forth. And you can have amendments, and the amendments generally should comport with the law required to have an agreement in the first place. So some states will require financial disclosures again, and so those are the sorts of ways that people and oftentimes they're not they are surprised when they come in and they say that our agreement is bulletproof, or that we've done this and that. And you go into and you explain to them, hey, not so fast. And it really depends state by state, but hopefully people get a flavor of what things come up in these divorces, because that's oftentimes where you see an agreement attacked or defended.
Yeah, absolutely. I have two final thoughts or questions that I want to ask you that our listeners are probably wondering. What state should you do the prenup in? And what state, and what happens if you move and divorce in a different state?
Well, I can tell you that New York has an unbelievable amount of case law. Florida does as well. California, so talking about celebrity divorces,
yeah.
Barry Bonds, the disgraced, a baseball player. I was a baseball player. He has a seminal case in California. So those are three states, at least there's predictability in the sense of, that you've got really known rules on what is required in terms of an enforceable agreement. But I mean, Utah is, I've spent a lot of time in Utah. A lot of Utah people are born and raised, and, they come back. So I would say if you have a pretty good idea, if it's two people, one may have gone to the U, the other may have gone to BYU, but that you're going to stay in Salt Lake, don't go and pick Florida just because there's a lot of law and predictability. I would, suggest get a Utah agreement, but there is a choice of law provision. So you will have a choice of law. So what that means is that you choose the law. I have a current case right now where they were originally from Kansas City, but they moved to New York. They had Kansas City lawyers drafting the agreement. Because that's where their family, they had the connections and they were familiar, but they selected New York. Now they're here in Colorado. And ultimately what happens is the Colorado court is supposed to apply New York law. But again, you get into these risks of, bringing in some other state's law. I've hired lawyers from Chicago, Illinois, where they relocated from Chicago to Aspen, Colorado, where I'm located, and we're having to bring in an Illinois expert on family law, and that it adds to the expense. So it's one of those things where you generally can pick the state in the agreement and apply that state, but states' laws change,
right?
And people change; they move across, the country. So I think the default is pick the state in which you have a pretty good idea that you're going to be living there. And then if not, then, pick a state that has some characteristics that are similar. So community property, state tax, there's certain, issues that are really going to matter for people. I know in Texas, Jill, where, you have some time in Texas, that, can really matter. I mean, Texas, as far as I understand it, doesn't have alimony. So I think it really depends on where you're living and what the aspects that you want to cover in your agreement.
Yeah, I absolutely agree with that. So if you know where you're going to live, you're pretty certain where you're going to settle down, do your prenup in that state pursuant to their laws. It will be the best, obviously, and the best enforceability if it's you divorce in the state that you actually drafted the prenuptial agreement. But again, we know that that's not going to happen. And with these uniformed, states specifically, I mean, their whole purpose is that they've agreed that they will adopt and enforce the enforceability of contracts from other states. It's the same with child support and with child custody. Like every state will enforce a child support order, no matter where it was.
Yeah, that said though, Jill, there like California, for example, I'm not licensed there, but I understand it. There are some pretty significant differences. So California, the burden of proof of what happens in terms of if there's a divorce and an issue on a premarital agreement. So in California, the person that wants to enforce the agreement has to show that various things happened, such as that lawyers were involved, that it was in writing, and then the burden shifts to the other person to say, well, something that, that I was under duress or I was coerced, and the burden switches. In Colorado, an agreement is presumed to be enforceable. The burden is on the person challenging it. And so those burdens of proof can vary between the states, and also whether or not property or support alimony can be waived. There's some pretty considerable differences across the country on the enforceability of those sorts of provisions. So those things can really matter. And so if anyone has an agreement and they think that, there's a risk of me getting a divorce, you probably should consult with an attorney in your state. And if you're in Utah, check out Jill, so that you can know whether or not your agreement is likely to stand up if that is on the table.
Yeah, I love that. I appreciate that, because that's what's hard is, Ryan knows we went to law school and we had to learn a very, very general law that's not even practiced, and then we go to each state and it's so different, and family law is exactly that. It's so different in every state, and so that's why we always suggest you always want to meet with an attorney, a local attorney specific to your state, not just your state but your county, specifically, so that you can ensure that you are protected the best way possible, because yeah, Ryan's the expert in Colorado. I know my stuff in Utah, and that's why we use each other and benefit from each other, because Ryan knows his lane, I know my lane. So if you're thinking that as well, I agree with Ryan, is just make sure that you are talking to people, an attorney specifically, about the enforceability of your agreement, especially if you're getting in a divorce in a different state. It just makes sense. With that, Ryan, I just want to wrap up. Final thoughts with prenuptial or marital agreements.
I would say if you're consulting or thinking about getting an agreement, I would strongly encourage you go to an attorney that has experience with drafting premarital agreements. You don't want to later claim malpractice against some general practitioner. So estate planning attorneys, family law attorneys, I would go to someone with experience if you're consulting or thinking about having a premarital agreement. Likewise, if you are considering a divorce, whether you are the one that's protected or that you're the one that you want to challenge it, go to an attorney in your area that is a combination of what Jill said, and knowing the county and the judges and the particularities of that jurisdiction, but also has experience with premarital agreements. I mean, these agreements are challenged fairly frequently.
Yeah.
And so I would ask that attorney, how, if you've had any sort of experience challenging or defending these agreements. Generally speaking, if you're defending, you want to open up the file from the other attorney or the agreement when it was drafted. So you want to disclose all of those emails, and you want to go to the attorney and ask them, hey, I need a copy of your file, your billing statements. Those billing statements from the drafting are really important because it gives you kind of an outline of what happened. So if it was just, there was no other attorney involved, you'd probably see that in the billing statement. If it was, another attorney involved, because sometimes these agreements will not disclose whether or not attorneys were involved. And so those can be really critical elements to whether or not an agreement is enforced. So I would ask someone if they've had any experience litigating these issues, and really go with who you're comfortable with. But that was something that I would suggest to your listeners.
I think that's awesome. Thank you so much for your advice. Thank you for being here. What a cool job you have. I'm sure you have some interesting stories that we should talk about over lunch.
Appreciate it, Jill.
Thank you for another episode of No One Dies from Divorce. Remember, if you have a topic or a question that you are really interested in me talking about, I'd love to be able to get an expert on to help answer those questions. You can email me at community@jillcoyle.com or go to my Instagram and go ahead and shoot me over a personal message. We would love to be able to answer and make sure that you are taken care of in what I would say is a tough time in your life. But remember, no one dies from divorce. Till next time, appreciate you, Ryan.
Appreciate it. Thanks, Jill.
Thank you for listening to this episode. If you enjoyed, please subscribe, follow, and share. I'd love to hear your questions and feedback. You can contact me at community@jillcoyle.com. See you next time. I am an attorney, but I am not your attorney. Any advice given on the podcast is general and shall not be construed as legal advice.